Hello everyone, myself Vaibhav verma and I am a part of LEXIS and Company as a legal intern, and today I am going to talk about a topic of bailment under Indian Contract Act. Bailment is defined under section 148 of the Indian Contract Act 1872, that is the delivery of goods by one person to another for some specific purpose, and upon a contract that these goods are to be returned when the specific purpose is complete. For example, giving clothes to washerman for washing, watches, mobile laptop for repair, parking the car, bike, etc. Bailment, term bailment being evolved from a French word baillir, which means to deliver, and it also means any kind of handing over. In legal sense, it means it involves change of possession of goods from one person to another for some specific purpose. Generally, we used to do a contract of bailment in our day-to-day life. For example, like giving a book to our friend just for reading, and after he read that book, he returned that book to us. So this is basically a contract of bailment, that is a contract between two parties upon a specific performance or for a specific purpose. Let's understand this topic by a way of another example. Let's say a car owner deliver his car in the service center for servicing. This is a contract of bailment where the car owner is the bailer and service center is the bailee. I deliver a piece of cloth to be a tailor for stitching. This is also a contract of bailment. So from this, the person who delivering the goods is known as a bailer, and the person to whom goods are delivered is known as bailer. In case of example that we give a book to our friend, we are the bailer and our friend is bailee, and after he read that book, that is a specific purpose in which we have entered into contract, is going to be called as contract of bailment. If owner continue to maintain control over the goods, there is no bailment. Let understand this sentence or these terms with an example, that is, if A gives his car to B, his neighbor, for 10 days, but at the same time he keeps one key with himself, and during this period of 10 days he used to take the car. Now this will not be the case of bailment, as A is keeping control over the property bailed. Now let's understand what is the essentials of a contract of bailment. Number one essential is existence of a valid contract. The existence of a valid contract is the foremost condition in bailment, which implies that goods are to be returned when the purpose is fulfilled. In our example of giving book to our friend, after he complete or reads the book, he must have to return the book to us for completion of the contract of bailment. However, finder of lost goods is also known as bailee, though there may not be any existing contract between him and the actual owner. Number two condition is temporary delivery of goods. The whole concept of bailment revolve around the fact that goods are to be delivered for a temporary period, and bailee cannot have permanent possession. Delivery of goods can be done through actual delivery or through constructive delivery. Actual delivery means giving the thing or the good to the person or the bailee, whereas the constructive delivery means that doing something which has the effect of putting the good in possession of bailee or any other person authorized by him. And last essential of the contract of bailment is return of specific good. The bailee is bound to return the good to bailer. after the purpose for which it was taken is over. If the if the person is not returning the goods, then it will not be a bailment. That in our example, that we have give a book to our friend, he has to return it to us, else this is not going to be a if he keeps that book to himself, then he such contract is not going to be a contract of bailment. Hope you like the video. Thank you.